Assalamualaikum and good afternoon to Madam Bella. Today, my group mate Nur Nabiha and I, Nur Nagila Ashikin, will present assignment 2 entitled Winding Up. Okay, so I'm gonna start with the introduction. Winding up, also known as liquidation, is a legal process that brings an end to a company's existence by collecting and selling its asset to pay off debts. So in Malaysia, the winding up of a company is governed by the Companies Act 2016. The process can be initiated either voluntarily by the company's members or creditors or compulsorily by a court order. So voluntarily winding up is divided into two, which is member voluntarily winding up and creditors voluntarily winding up. On the other hand, compulsory winding up, also known as a winding up by the court, is initiated through a petition presented to the court by the creditors, the company itself, or other authorized parties under Section 464 of the Companies Act 2016. In the context of partnership law, the winding up process is governed by the Partnership Act 1961. Similar to the corporate winding up, the process involves settling the partnership debts and liabilities, distributing any remaining assets among the partners, and dissolving the partnership. The dissolution of a partnership can occur voluntarily by agreement of the partners or compulsorily by a court order, often due to insolvency or other significant reason. Basically, the winding up process ensure an orderly and fair distribution of companies or partnership assets, protecting the interests of creditors and other stakeholders. It also provides a mechanism for investigating the affairs of the company or partnership, ensuring that any mismanagement or wrongful conduct is addressed. Okay, now let's look at the methods of winding up. There are two primary methods of winding up, which are voluntarily and compulsory. Voluntarily winding up can be initiated by the members or creditors of a company. Later, it is further divided into two types, which is members voluntary winding up and creditors voluntary winding up. Members voluntary winding up occurs when a company is solvent and able to pay its debt. The directors must make a declaration of solvency under Section 443 of the Companies Act 2016, stating that the company can pay its debt within a year. The process involves passing a special resolution by the members to wind up the company and appoint a liquidator to manage the process. For example, a company decides to cease operation and distributes its remaining assets to shareholders. The directors declare solvency and the members pass a resolution to wind up the company voluntarily. Meanwhile, creditors' voluntary winding up is initiated when a company is insolvent and unable to pay its debt. This process begins with the directors convening a meeting of creditors to discuss the company's financial institution. A resolution is passed to wind up the company, and a liquidator is appointed to manage the process. So let me give you an example. A company facing financial difficulties and unable to meet its obligation decides to wind up voluntarily. The directors call creditors to the directors call a creditors meeting, and the creditors agree to the winding up. Next, compulsory winding up. So compulsory winding up, also known as winding up by the court. It is initiated through a petition presented to the court by creditors, the company itself, or other authorized parties under Section 464 of the Companies Companies Act 2016. The most common ground for compulsory winding up is the company's inability to pay the debts as outlined in Section 465 Clause 1 subsection E, which I will be explaining later. So, for instance, a creditor petitions the court to wind up a company that has failed to pay its debt. The court grants the petition and a liquidator is appointed to manage the winding up process. The winding up of a partnership in Malaysia is governed by the Partnership Act 1961. Similar to corporate winding up, the process involves settling the partnership debts and liabilities and distributing any remaining assets among the partners and ultimately dissolving the partnership. Okay, so moving on, we will look at the grounds of winding up. So I will be explaining the first five of the section, and later it will be explaining by my teammate. So according to Section 465, Clause 1, Subsection A of the Companies Act 2015, it provides that a company may be wound up by the court if the company has a special resolution. A special resolution requires a majority of not less than 3/4 of the votes cast by members entitled to vote at a general meeting. So, for example, a company facing declining business prospects and unable to sustain operation may decide to wind up voluntarily. The members pass a special resolution in a general meeting resolving that the company may be wound up by the court. This resolution is then presented to the court, which may issue a winding up order based on the resolution. So next is Section 465 Clause 1 subsection B of the Companies Act 2016, that provides a company may be wound up by the court if it defaults in lodging the statutory declaration required under subsection 190 Clause 3. This statutory declaration pertains to public companies and is a critical compliance requirement. Under subsection 190 clause 3, a public company must lodge a statutory declaration with the registrar confirming that the company will not commence business or exercise borrowing power unless it has received a minimum subscription. Failure to lodge this declaration within the stipulated frame can trigger compulsions a company incorporated to undertake a large infrastructure project. However, due to the unforeseen, the company fails to lodge the statutory declaration within the required period. As Section 190 Clause 3, the shareholders or creditors recognizing this default may make a petition to the court for a winding up order. The court, when reviewing the petition and confirming the default, may order the winding up and also the creditors. Section 465 Clause 1 subsection C of the Companies Act 2016, a company may be wound up by the court if it fails to commence business within a year of its incorporation or suspend its business for a whole year. This provision ensures that companies do not remain dormant indefinitely, which could be detrimental to creditors and shareholders. So, for example, a private company incorporated to develop new technology product. Due to unforeseen regulatory hurdles and delays in securing funding, the company fails to start its business operation within the first year. So alternatively, if they had commenced operation but then suspend its business activities for an entire year due to the market condition, it will also falls under this ground of for winding up. So in these cases, shareholders or creditors can file a petition to the court for a winding up order. The court will review the circumstances, and if it finds that the company has indeed failed to commence or has suspended its business for the specified period, it may order the winding up of the company. This process involved liquidating the company's assets to pay off its debt and distributing any remaining assets to the shareholders. The ground for winding up served as a protective measure, ensuring that companies either actively pursue their business objectives or are dissolved to prevent potential financial harm to stakeholders, holding companies accountable for their operational commitments. So next is Section 465 plus 1 subsection D of the Companies Act 2016 that provides a company may be wound up by the court if it has no members. So this ground for winding up is crucial as it addresses situation where a company loses all its members, which can occur due to the various reasons such as death of the sole member in a single member company, or the resignation of all members in a multi-member company without any new members being appointed. So for example, a public company which initially had 3 members, over time, 2 members resigned due to personal reason and the remaining member passed away. As a result, the company is left with no members. So in this scenario, the company cannot function effectively as it lacks the necessary governance structure. Consequently, any interested party, such as a creditor of a former member, can file a petition to court for winding up under this section. The court, when reviewing the petition and confirming that the company has no members, may order winding up of the company. So this ground for winding up serve as a protective measure, ensuring that the companies maintain a proper governance structure as a protective measure, ensuring that that they do not operate without members. It also provides a clear legal pathway for dissolving companies that are no longer viable due to the absence of members. Okay, so for the last point is Section 465 plus 1 subsection E that provides a company may be wound up by the court if it's unable to pay its debt. This ground for winding up is significant as it addresses the financial insolvency of a company, ensuring that the creditors can recover their dues when a company is no longer financially stable. A company is deemed unable to pay its debt if it fails to pay a debt exceeding a certain amount within 3 weeks after a creditor has demanded payment. Event execution or other process issued on a judgment, decree, or order of any court in favor of a creditor returned unsatisfied, or if the court is satisfied that the company is unable to pay its debt, taking into account its contingent and prospective liabilities. So, for example, a company which has taken a loan from a financial institution to expand its operation. Due to the poor market conditions and mismanagement, the company is unable to generate sufficient revenue to meet its debt obligations. The financial institution issues a statutory demand for repayment, but the company fails to pay the amount within the stipulated 3-week period. So consequently, the financial institution petitions the court for winning up orders according to this section. So the court, when reviewing the petition, confirming the company's inability to pay its debt, may order the winning up for the company. It also serves as a protective measure for creditors, ensuring that they have a legal recourse to recover their dues when a company is insolvent. It also promotes financial discipline among companies, encouraging them to manage their debt responsibly. I think that's all from me. I'll pass to the next presenter to continue. Thank you.
Good evening to Madam Bella. My name is Nur Nabiha binti Anwar, and today I'll be presenting my part, which is the grounds for winding up a company. So moving on to the section 465 clause 1 clause F, where the directors acted in their own interest. The Companies Act 2016 allows courts to wind up a company if directors violate their fiduciary duties, abuse their power, or act unfairly to shareholders. This section allows the court to wind up a company if directors have acted in their own interest or if their actions appear unfair or unjust to their members. This justification is part of the larger just and equitable theory which allows courts to intervene when a company's directors violate their fiduciary duties or when its management departs from its initial objective. The shareholders are protected against directors acting in their own best interest, such as misappropriating money or giving out excessive compensation without shareholder consent. In the case like Lim Shen Li against Ho Shen Li, Cynthia Berhad and others, the court determined that directors must behave in the company's best interests and that the self-serving behavior, even if indirect, may be grounds for any application. Moving on to the next section, which is section 465, clause 1, clause G, of the Companies Act 2016, which allows a court to order a company's winding up when the constitutionally fixed period has expired. This clause applies to companies with a set lifespan or those established to achieve a specific goal. Companies without these provisions are exempt from winding up. The court ensures a fair winding up to protect creditors, shareholders, and other stakeholders. An interest party can request winding up from the court. For example, a joint venture company with a highway project can request winding up after the project is completed and the allocated time has passes. In the case of Syarikat Project Lebuh Raya Utara Selatan Berhad, a project-based company with a 50-year 15-year deadline for project completion filed for winding up to collect unpaid payments. The court ruled that the companies must be wound up in the accordance with this section, highlighting the end of the legally stipulated period as justification for dissolution. Moving on to the next section, which is section 465, clause 1, clause H, regarding the just and equitable. This section allows court to consider equitable considerations in cases where strict legal rights alone may not sufficient. This includes instances such as breach of corporate substitute, fraudulent business practices, irreparable member relationship, and loss of confidence in management. The court prioritizes equity and fairness over rigid legal rights, and winding up is considered as last resort of other options are unavailable. In cases where a company fails to set up new objectives, its credibility is damaged by dishonest activities that lock in decision making and a decline in confidence in governance. The just and equitable basis may be applied in dealing with cases of severe mistreatment or poor management. Moving on to the next section, which is section 465, clause 1, clause I, where the Companies Act 2016 allows a company to wind up if its license or permit to conduct its primary business has been revoked or cancelled. This clause ensures the proper dissolution of businesses that cannot legally continue due to losing regulatory authorization. Reconvention grounds include the company's inability to function lawfully, violations of the law, and non-compliance of statutory requirements. For example, a financial institution that violates capital requirements loses its license from the Bank Negara Malaysia. And in the case of Perwaja Steel Sdn Berhad against Suruhanjaya Syarikat Malaysia, the court granted the petition stating that the business lose important license due to law breaking must be ordered to close down. The last section, which is section 465, clause 1, clause J, where the Companies Act allows a company to be wound out if it is found to be operating unlawfully, such as money laundering, fraud, or dealing with illegal goods. This clause ensured the dissolution of businesses involved in policy opposing activities for justice and public order. The court can act under this clause to protect society and preserve public trust in the corporate regulatory framework. A company found guilty if of such activities is considered a front of organized crime. And in the case of Pre-Hubsing Company's neighborhood 2020, the court ruled that the business was wound up due to its illegal trade of counterfeit goods, where it highlighting the application of this section to address the intellectual property law breach. To conclude, the process of winding up, which terminates a company's legal existence, is necessary to corporate and partnership law. The procedure for winding up, such as court orders for filing or insolvent businesses or voluntary winding up started by the creditors, are outlined in the Malaysia's Company Act 2016. The important aspect, which is the fair treatment of stakeholder, safeguarding the public interest, providing closure for stakeholders, and judicial oversights. Directors, stockholder, and creditors are important stakeholders in companies, which are emphasized in the Act as distinct legal entities. The Partnership uh, Act of 1691 covers the partnership law, which deal with partnership dissolution and makes partners personally responsible for obligations. The winding up procedures protect creditors, uphold corporate accountability, and preserve Malaysia's business environment. And it is a very important legal process of settling conflicts, paying off debts, and concluding economic activities in a fair, open, and law-abiding way. So I think that's all from us. Thank you, madam.